Hi, this is David Ruben from the Ruben Law Firm. I want to put together a short video and explain to you, anyone that's watching this video, whether you're going to represent yourself in a custody, child support, family law case, or whether you're an attorney in the state of Maryland and you're looking for information because you don't have as much experience perhaps as I do, or if you're looking to hire our firm and you want to see how we approach it. And what I've learned over the last couple years in many cases that I've won, and when I say I win, what I mean is I either got everything that my client was asking for or most of what my client was asking for, or because there are certain cases where you don't get exactly what you want, but if you walk out of the courtroom and the client says, you know what, I didn't get everything I wanted, but you put my case forward the best way possible, and I'm happy with your services, and I'm glad we went through this. This is what I've learned the most. Preparation is important, experience is important, but litigating the case, from the moment you walk in that courtroom, what you have to do as a family law lawyer, and really any kind of lawyer in any kind of case, is what I call read the room. There's going to be a judge in that case that has just looked at the file the night before. For example, in Anne Arundel County, there's 15 judges. Sometimes people say, well, what are those Anne Arundel County judges like? Or are they different than those Baltimore County judges like? Or I heard that judge is mom-oriented or dad-oriented. I heard that judge. That's not the way to approach it. I used to do that because that's what some lawyers said to do. That's not the way to approach it. When you walk into that courtroom and you're ready to try your case, yes, you should be prepared. Yes, you should be ready. You need to be ready for anything because you don't know what side of the bed that judge woke up on that particular day and how that particular judge feels about the kinds of facts in your particular case. So if you walk in thinking you're prepared and know exactly how you're going to present your case, you're likely going to lose because litigation is almost like a football game. You can prepare all you want, but as soon as that ball is kicked off, things change. Every play is different. Somebody gets hurt. A witness doesn't show up. The judge has a dentist appointment in the afternoon. The clerk changes. You get a cough. Something will happen during the period of a trial that will change things up. A witness will say something that you had no idea that they were going to say. Your client will say something that they shouldn't have said. The other attorney will. Something may happen. So the key to litigating in a family law case, coming from my experience, is when you walk in that room, you be prepared, but you listen and you read the room and you get a sense of what the judge is doing. You watch that judge and his or her expressions and the questions they ask and the way they're conducting themselves. And when you're asking questions perhaps of the other client and you're cross-examining them and the judge sustains an objection, you learn from that and you don't make that judge mad going from that point forward. Because a lot of what happens is, because it's hard for these judges to make decisions, they may side with one of the attorneys. They may like how that attorney is approaching the case. Whether the facts are right or wrong, it might make sense to them. Because most cases that are litigated can go either way. They're usually not slam dunks. If they're slam dunks, we're going to settle the case. If my client has the worst case in the world, I'm going to try to settle that case and get the best result possible so I don't get killed in front of a judge. If my client has a great case, then I'm going to go try the case, but the other side's probably going to settle. So most cases that actually go to trial, there are difficult issues. When you go in, your job is to read that judge, read the room, listen to questions, take notes, change up, make a plan, and execute on it. And all you can do at the end of the day in any family law case is present your client's case in the best manner possible. And again, that's something you can't have any idea exactly how that's going to be before a trial. You can have a game plan, but you have to be prepared to change it up during it. And at the end of the day, whether you get the result you want or not for your client, you want your client to walk out of the courtroom, because this has happened to me. And it's not a great feeling because we didn't get exactly what we wanted. But I can't remember the last time I either didn't get what I wanted from my client, didn't get most of what I wanted from my client, or even if we didn't get what we wanted, we walked out of the courtroom and the client said, you know what, David, I know we didn't get what we wanted, but we put our case forward, we did the best we could, and I can live with it. And that is what's really important. And the key, in my opinion, again, and I'll say it again, is to read the room. If you have any questions about a trial or trial procedure or divorce case, custody case in the state of Maryland, feel free to give us a call. We'll be happy to help you.